Hey everyone, it's Nicolette here from AIVS. If your partner visa has been refused or cancelled, first things first, take a deep breath. I know how overwhelming this feels, but I promise you, a refusal is not the end of your journey together. I'm going to walk you through exactly what happens after a refusal, what your options are, and the pathways that might be still available for you and your partner. So if the department refuses or cancels a partner visa, it means they weren't satisfied that the application met all the requirements under the migration regulations. You'll always receive a written refusal or cancellation notice, which outlines the reasons of the decision, the legislation used, and whether you have review rights. Now let's take a look at what a refusal means for your application. If you applied for your partner visa onshore, there's some good news. A refusal usually comes with review rights. So your first option to lodge an administrative review tribunal, also known as the ART appeal. You'll generally have between 21 to 28 days from the date of your refusal to submit this appeal. Your refusal letter from the department will clearly tell you how many days you have, so make sure you check that carefully. And just so you're prepared, the current fee to apply for a review for most migration decisions is $3,580. So what does the ART actually do? The ART takes a fresh look at your case. This is called de novo review. That means they're not limited to what the department looked at the first time. You can give them new evidence, explain your situation more clearly, and update anything that was missed. The tribunal member reassesses your application from scratch and makes their own decision. So what happens to your bridging visa? If you are holding a bridging visa A from your original partner visa application, lodging an ART appeal will usually keep you lawfully in Australia during the review. And if you need to travel while you're waiting, you may be able to apply for a bridging visa B depending on your situation. For offshore partner visas, the applicant can't appeal, but sponsor can. If your 309 visa is refused, the Australian partner, your sponsor, usually has the right to take the case to the ART to take a second look. The refusal letter will confirm this and explain how long you have to apply. Unlike onshore partner visa refusals, the applicant can stay offshore throughout the whole visa process. But the sponsor in Australia can still participate, provide evidence, and support the appeal. When you appeal a partner visa refusal to the ART, they can make one of four decisions. One, they can affirm the decision. This means the refusal stands and the ART does not believe the visa criteria were met. Your bridging visa usually ends 28 days after the ART decision, unless you take a further action, such as a judicial review. When this happens, you must consider your next steps, such as reapplying for the visa, applying for a judicial review, or applying for another visa. 2. If the ART remits your case, it means they've overturned the refusal. But instead of granting the visa themselves, they send this back to the department with specific instructions. The department then has to reopen your application, follow those instructions, and check whether you meet the remaining visa requirements. And the good news is, if everything else is in order, a remitted case often leads to the visa being granted. The ART also has the power to vary or set aside the original decision. If they vary the decision, it means they're changing part of the department's decision. They can also set aside the refusal entirely and substitute a new decision. Note, these outcomes are less common in partner visa matters. What if you went to the ART and they still didn't agree? You still have options. Judicial review. This goes through the federal court and family court. This isn't about evidence of your relationship anymore. It's about whether a legal error was made in the decision-making process. Judicial review is only about one thing. Was there a legal or jurisdictional error in the way the decision was made? If the court finds a legal error, they send the case back to for reconsideration. If no legal error was found, the original refusal stands. Ministerial intervention is a final rare pathway. This is not a second appeal, a process you have the right to access, a way to re-argue partner evidence. The Minister has personal discretionary powers to intervene only in exceptional or compassionate circumstances. Examples might include serious hardship, compelling humanitarian issues, or unique factors affecting Australian children or families. Even then, the Minister is never obliged to intervene. Sometimes a refusal doesn't include ART review rights. For example, if the application was invalid. In these situations, the following steps might include judicial review or a brand new partner visa application if you're eligible. Can you reapply for a partner visa? In most cases, you absolutely can, and many couples do. Before reapplying, it's really important to consider the following. Check that you still meet the eligibility criteria. Understand exactly why the visa was refused. Fix the gaps or concerns the department raised. And make sure your evidence clearly meets the visa criteria. If you're planning to reapply onshore and you've become unlawful, you may also need to meet Schedule 3 requirements or request a waiver. And this area is extremely strict. So please get proper advice before relodging, just to make sure you're choosing the right safest and strongest pathway forward. I know a partner visa refusal can feel heartbreaking, but you still have pathways, and you absolutely don't have to go through this alone. I help couples every day navigate refusals, appeals, Schedule 3 issues, and reapplications, and I'd love to support you too. If you want to talk through your refusal letter and understand your next steps, you can book a free 15-minute consultation with me. We'll go through your options together so you can feel comfortable about your next move.